Good afternoon, everyone. My name is Lluc Cerda. I'm the managing partner of the Calgary office of Samfiru Tumarkin, the Western Canada Employment Practice Lead. We are here today for your employment law question and answers period. We are going to try and answer as many of your employment law questions as possible in the next half hour. So feel free to put your questions in the chat, anything related to employment law. I'm going to try my best to give you the answer to any of your questions. Um, while we wait for your questions to come in, I'll just start with probably what's on a lot of our minds, which has been the announcement by the Trump administration that they're going to impose tariffs on Canadian goods and exports of up to 25% starting on February 1st. Of course, as an employment lawyer, the concern there is that that'll have a knock-on effect on employment in Canada, and what are the consequences for Canadian workers? Are we looking at potential layoffs, potential terminations for these employees? And does the fact that that's a result of tariffs, does that affect employment rights? So in other words, if your employer has to lay you off or has to terminate you because the tariffs are causing economic distress, does that mean that you would, potentially lose your rights as an employee? And the answer has been no. So even if your employer is hurting financially and has to lay you off or has to terminate you as a result of these tariffs, doesn't that means that you still have a right to your full severance entitlements? Okay. We had a similar situation when the pandemic first started. In March 2020, a lot of employers had to lay off staff or had to straight up terminate them. And the courts were asked by a lot of these employers, are we really still responsible for paying our employees all this severance, even though, we had nothing to do with the reason why this happened? Of course, have consistently said you still have an obligation to your employees. Adverse economic conditions do not dispense you from providing severance pay to your employees. Which also reminds me that a lot of those employees were actually not terminated officially, but laid off. And just to remind you that unless there is something in your employment contract saying that your employer has a right to lay you off, your employer does not have that right. You can treat that as a termination and go after your severance if your employer lays you off without your consent. Now, if there's been a past practice of layoffs in your company, then that past practice indicates that your employer has the right to lay you off. And what is a past practice? If you've been laid off once, have been recalled to work, and went back to work, that implies that you were okay with being laid off during that period of layoff, which means that you are theoretically okay with being laid off again. But if there is no past practice, you've never been laid off before, there's nothing in your employment contract allows layoffs, you are allowed to treat a layoff as a termination and pursue your full severance right away. And even if there is a past practice of layoffs, know that the layoff cannot last forever. All right. So in every province that we operate in, being BC, Alberta, and Ontario, limit how long a layoff can last before it becomes a termination, and therefore before you are entitled to pursue your full severance. All right. So I just want to, allow people to approach this very uncertain time with a little bit of certainty of what their actual employment rights are. The hope is none of this comes to fruition and everything continues as it did before. We'll see what happens on February 1st. All right, we have a question come in from Kelvin Kush. Kelvin is asking, can my employer cut off my pay if I'm on disability? While on disability, my doctor stated I could only work 4 hours a day. I'm a salary employee. Because of this reason, HR decided to pay half my wage. I'm not exactly sure what you're asking me, Kelvin, but I'll tell you what generally happens. Generally, people might have, long-term or short-term disability insurance through work or even workers' compensation or something like that. And their doctor says you can only work, half hours, half time, all right? And so your employer will pay you for the hours you actually work, and the LTD will top you up or workers' comp will top you up. Now, in situations where you don't have LTD or short-term disability and workers' comp is not involved, if you are not working your full hours because your doctor has restricted you from doing so, then yes, it's normal that your employer would reduce your pay, even if you're salaried employee, because you're working less hours as an accommodation to you. So there wouldn't be an expectation that you'd be paid your full salary for doing part work, okay? So if you do have STD, LTD, or workers' comp in the picture, they should be able to top you up for a period of time. And I'm not exactly sure either, Kelvin, maybe you can mention this, how long you expect to be on part-time. Is it just a matter of a few weeks, or is this a permanent restriction or something like that? That might help clarify my answer. We have another question coming in from Lanana. Lanana is asking, is it legal for an employer to prohibit all staff from discussing salary? So Lanana, employers can make rules in the workplace that employees are expected to follow. There is nothing illegal currently in your employer saying that you can't discuss salary at work. Okay. Now, so they're not doing anything illegal by saying that. What happens if you do discuss your salary at work and your employer finds out about it? Potentially, they could institute progressive discipline. So I don't think this is a situation where they'd be able to say outright, you discuss salary with your colleague, that goes against policy, this is a violation of the policy, so we're terminating you for cause. They would have to follow some sort of progressive discipline policy in that regard. So they might give you a warning saying, listen, that's against the policy, don't do it again. And the warnings would increase potentially to the point that, after a written warning, potentially a suspension or whatnot, you might be terminated for cause. It seems very arbitrary. I agree with you on that. I personally think people should be free to discuss their salaries. There's no protection, though, in the law for employees who discuss their salaries right now. It's been discussed a lot about, allowing employees to discuss their salaries freely, but it hasn't made its way into any of the laws protecting employees' right to do that. All right, so that allows the employer, unfortunately, currently, to have these kinds of policies, and there being a requirement that you follow them, failing which you might be disciplined. Okay, so that's where we stand right now. I don't think it's particularly fair, but that's the way it is, unfortunately. Oh, Kelvin has followed up here. Kelvin is saying that he's been put on modified duties due to depression and anxiety from work. So, the reason why you're requesting modified duties, so long as it's related to a disability, is fine. Nothing wrong with that. Like I said, what I was asking you, and I think you put this in before I asked you that, is how long this is expected to go on for. Are we talking about this is a few weeks potentially, or is this something that's more long-term that you'll never be able to go back to work full-time? You'll always have to be on half days because of this, right? Is it a permanent restriction? Is it temporary or whatnot? Okay. But I think clearly, if you're not working full-time, even if you're salaried, you're not going to be getting full-time, your full pay, unfortunately. We have another question coming in from YouTube from Moonlight. Moonlight is asking, if you're placed on a paid suspension, is an employer allowed to be late with your pay? So no, Moonlight. If you're on paid suspension, you should be getting paid just the way you always have been. Regarding laws, there are laws that say how and when you should be paid. All right, those laws are called employment standards legislation. There's some in BC, Alberta, Ontario. They are enforced by the directors of employment standards in those provinces, also sometimes called the Ministry of Labor. So if your employer is late in paying your wages, you can contact the Ministry of Labor, the Director of Employment Standards, and have them investigate as to why your pay is being paid late. Okay, that's my first impression of what the answer is. Moonlight, if your employer has told you or given you an explanation or a reason why the pay is late, then definitely put that in the chat. Maybe I'm missing something here, but generally pay has to be paid on time. All right. So and if it's not, you know, whether you're suspended or not doesn't change the fact that you have to be paid on time. All right. We have another question coming in again from YouTube from Atamaris. Atamaris is asking, can remote working employees be reprimanded for loss of working hours due to internet or power issues? No, frankly. So reprimanded, I'm not exactly sure what you mean by reprimanded. Um, Generally, in the employment context, we're talking about discipline. Okay. So, can you be disciplined for doing something wrong? And discipline can go from anything from a verbal warning up through a written warning, a suspension, and something like that, and eventually a termination for cause. Okay. So the employer has a wide toolbox in terms of discipline it can impose on you. It can impose on you, but it can only impose that discipline on you for misconduct. Okay, so before an employer can discipline you, you have to be guilty of some form of misconduct. So what I'm reading here is that your internet provider is not all that reliable, unfortunately, and that's causing you to lose hours of work. So maybe your employer expressed frustration at you with that might not be, in their view, discipline. But if they've given you a written warning or a verbal warning that if this happens again, there will be consequences, that seems to me unfair, because this is outside of your control, whether your internet is working or not. That said, now you know your internet is not all that reliable. What have you done, or what will you do to mitigate that risk if it happens again? Would you consider, for instance, hotspotting your phone, or going to a library, or going into the office if there are issues with your internet, right? This is a discussion you should have with your employer. What can I do if this happens again, right? So I don't lose the hours, right? Because even though your internet might be down in your specific neighborhood, it's likely not going to be down, across the city, right? So there are ways of mitigating that. What would be the conversation for you to have with your employers? What would be the right solution if this happens again, rather than throwing your hands up in the air and saying, "Well, I can't do anything. There's no internet." Or there might very well be internet at the cafe down the block, or at the library, or there might be an office you can go into for the day for the internet. Okay, so definitely try to see if there are ways of preventing this from happening in the future. Not that the internet will drop, but that it results in several hours, even days of lost productivity. We have another question coming in from Alina Combs. Alina is asking, if you cannot prove workplace mobbing, but you feel you have suffered targeting, abuse, and severe mental distress from the workplace, also due to trying to see an attorney, what can you do? So this often happens where people come and see us and they say, I think something is happening, but I can't prove it. The fact is, if you're talking to lawyers, if you're trying to engage the court system, there is burdens of proving your case, okay? Now, you might not have currently the email or the text message chain that shows that group is talking behind your back and trying to, bully you. That can be subpoenaed, essentially, to use a colloquial term. That can be subpoenaed through the litigation process, but you have to have something, right? I mean, so basically, I'm not exactly sure. You mentioned you've suffered targeting, abuse, and severe mental distress. I don't know why or how that actually happened. So one thing that I see clients when they come see me saying, I've been the victim of bullying. Yes, but what exactly happened? What exactly did they do? Did they, withdraw work from you? Did they try to isolate you in the break room? Um, uh, are they rude to you when you don't speak to them? Are you suffering concrete, career sabotage? What exactly are they doing that you're calling bullying, right? And then once we have that, then we have a way of establishing if that happened, and we can call that bullying. But now we just need to prove that actually happened, right? So there are ways of obtaining that information if it exists, but first we have to clarify what it is the claim is, how you've been a victim of targeting, abuse, and severe mental distress. So you need to kind of flesh that out a little bit. But if you can, then you can make a harassment complaint through work. So you go to human resources and say, I've been a victim of harassment. Here's what happened to me, and they have an obligation to investigate that. And if they fail to investigate that, or let the other side get away with it when in fact they shouldn't have, that might amount to a constructive dismissal, which would entitle you to quit but pursue your severance, because no one really is required to continue to work in an environment full of hostility, a degrading work environment, or anything like that, or an environment where they're being harassed or they're the victims of violence in the workplace. So I don't want you to think that you have to stay in that environment unless you can prove what they're doing. You can already start the process of having this investigated, either through human resources or by contacting a lawyer. And so if you're looking to get a bit more information or see if there is enough proof already, things can be proven in a variety of different ways. You don't really necessarily need that smoking gun of, here's the text message exchange between my two colleagues where they're saying that they want to, inflict mental distress on me or anything like that. If you're looking to see, how can I prove this, reach out to us. We can look at the matter and discuss with you if you have a case currently, or if not, how do you build your case if this behavior is ongoing. And so you can reach out to us at employmentlawyer.ca. See the website there, employmentlawyer.ca. That will allow you to get in touch with us and schedule an appointment with one of our legal representatives to discuss your case with you. We have another question coming in from Philip L. Philip is asking, suppose I'm doing something that my employer prohibits but does not reprimand me. If it becomes a problem for other employees, could they terminate me to avoid the issue? Philip, this is quite vague. I'm not exactly sure what it is that you're doing. Essentially, I'll just suppose that this is what you're asking. For instance, if you are, let's call it, leaving 15 minutes early every day, right? And your employer is concerned that if you leave 15 minutes early every day, other employees are going to start doing that, and then they'll terminate you, as an example. So in my view, they wouldn't be able to do that, all right? So there's a few reasons why. So firstly, if you're leaving 15 minutes early and your employer knows that you're leaving 15 minutes early and doesn't do anything about it, they need to know. But if they do know, then the legal term is they've condoned you leaving early. They have allowed that behavior to happen. So that behavior now becomes, in fact, not something they can discipline you for. It becomes something that you're allowed to do, all right? Leaving 15 minutes early, okay? Supposing they don't see it that way and they say, well, you've been leaving 15 minutes early for the last 2 years, now everyone's doing it, so we're going to terminate you. I don't think they have a strong leg to stand on. Because they've known all this time that you were leaving early. And if they wanted to change that, they should have said, no more of that. And if you do it again, we're going to start disciplining you. Leaving 15 minutes early is not the most serious thing you can do in a workplace, of course. We were just talking about workplace violence and things like that. There are much more serious things that you can do. So they would have to follow progressive discipline before they could terminate you for cause. And one of the things they would have to do is establish that you were aware that what you were doing was not allowed. Okay, so if You're, for instance, leaving 15 minutes early. You're saying bye to your boss on the way out. Your boss knows that, quitting time is actually 5. It doesn't make a big deal about it. It never really bothers you about it or calls you on it. They would at the very least have to tell you, okay, that stops today. And if they haven't done that, even if other people start doing it, they can't make an example of you. They can still terminate you, but you would be owed your full severance. It would be a without cause termination. Okay, they can't terminate you on a for cause basis. We have another question coming in from Heine De Vries. I hope I pronounced that correctly. Heine is asking, I just found out the original employment agreement I signed had limited my severance to the minimum in the Employment Standards Act, even though I had worked for them for 18 years. Am I screwed? Absolutely not, Heine. So I don't know, have you been, you're following up here. They offered me 8 weeks pay with benefits and 18 weeks salary without benefits. And you were there for 18 years. So Heidi, this is one where you definitely want to have us review firstly that contract and your severance. You might be leaving tens, if not tens of thousands, if not sometimes hundreds of thousands of dollars on the table if you don't look at that, if you don't have us review that. Reach out to us at employmentlawyer.ca. Run, don't walk. We can look at that contract. We can let you know whether that clause is enforceable. In my experience, a very big majority of these contracts that have termination clauses is what they're called, clauses that limit how much severance you're owed if you're terminated. A very large portion of those clauses are unenforceable. They're drafted in a way that makes them illegal, or as seems to have happened in your case, midway through your employment, they ask you to sign a contract limiting your entitlements. They don't explain what it's for or what you're giving up, and they don't really give you anything in exchange. There's a lot of ways to attack these kinds of clauses. So do not think that all is lost, okay? You are not screwed. Give us a call. We'll be happy to take a look at that for you and let you know what your options are and what your rights are, all right? All right, Alina Combs is following up. She said, I saw a workplace mobbing attorney, bullying, breaking, heard my employees talking about at work. HR failed to investigate after I had told 2 human resource representatives. The police, EEOC employees openly talk about at work. Attorneys in my areas couldn't believe this was happening. They didn't understand workplace mobbing. I'm not exactly sure I understand what workplace mobbing is. I hear about workplace bullying. I don't see how it's different. I guess a lot of people are involved in the workplace bullying. Do make sure to get in touch with us. I need more details at this point, Elena. I think we're talking a little bit in the abstract, and I'm not exactly sure what exactly is happening to you at work, and how the police got involved in all of that. I can tell you, if you make a complaint to HR and they absolutely do nothing about it, then you can contact the Health and Safety branch of the Ministry of Labor to investigate. All these health and safety legislation in BC, Alberta, and Ontario require employers to investigate claims of workplace harassment and violence. All right, and if the employer fails to do that, you have a recourse by making a complaint to the Health and Safety branch of the Ministry of Labor or the Director of Health and Safety, as the case may be. So that's where you are right now. That's the option you have available. Otherwise, contact us at employmentlawyer.ca, and maybe we can get a bit more information on what exactly it is you say happened, and we can go from there. Philip L. is following up. Philip L., you'll remember, was the one who was saying that the employer had let him do something for a little while and was afraid that once other employees started doing that, he might get terminated. And I mentioned, it's kind of akin to leaving early, for instance. If your employer allows you to do that for a while, can they then change their mind and terminate you? So Philip has followed up saying, thank you, employment lawyers. Samfiru, Tumarkin, employment lawyers. Your example perfectly addressed what I wanted to ask. So great. I'm glad to hear it, Phil. Glad I could be of assistance. We have another question coming in from YouTube from AWW6T. What can you do if a harassment complaint was made in bad faith, and as a bullying tactic? So in this scenario, my understanding is that what you're saying is that you were accused of harassing behavior, but that complaint against you was made in bad faith, and was itself a form of harassment. Okay, so yeah, so generally bad faith, untrue harassment complaints are not allowed. Okay, that said, it's only the employer who can discipline its staff. All right, so you can't necessarily discipline the complainant, in this case yourself, but if your employer decides that complaint was made in bad faith, then they can discipline the employer. It gets kind of tricky in the sense that you really have to prove that it was knowingly made, that they knowingly made a false accusation, right? Because when you make a complaint of harassment, or you make a complaint to enforce your rights under employment standards or health and safety legislation, you shouldn't be retaliated against for having done so, even if the complaint is ultimately unsuccessful, so long as the complaint is made in good faith, though, right? I mean, if it's for a corollary way of it's just to harass you, right, then that can require discipline. But it kind of parsing all of that can get a bit complicated. So it's hard for an employer to decide, well, is this done in bad faith? What proof do I have of that? And so that's maybe what I would ask you, AWW6T. What proof do you have that it was made in bad faith? Right? Obviously there's going to be some bad blood between employees when these harassment complaints happen. But we have to prove that this was made in bad faith, knowing it was untrue and things of that nature, right? I did just read an article recently where someone had, doctored text messages showing harassing behavior. So they had straight up invented the text messages. So that would be something, right? But if someone is saying they truly felt threatened by your behavior, unless that behavior never actually happened, you have an alibi or something like that, they're inventing it from all parts, then their subjective interpretation, although it might not amount to a finding of harassment, will probably take it out of the bad faith territory generally. Okay. So Elena has followed up, saying that she's been victim of break-ins to my employees I've worked with. The employees openly talked about it at work, and she follows up saying that she lives in that you live in Ohio, Elena. So unfortunately, I got to stop there. I don't know if I'd be able to answer that question. I have no idea what the laws are related to employment in the United States, especially as they relate. I really am only competent to talk about the laws, the employment laws in British Columbia, Alberta, and Ontario, Canada. So anything you heard me say prior, was based on the presumption that you were in one of those three provinces. So even if you did take anything away from what I said, now that I know you're in Ohio, I don't even know if what I said would be correct in Ohio law, right? You'd have to check with a local attorney. They would know better than I do what your options are there. All right, we have time for one last question. It's coming in from Reddit from KHoop55, who is asking, my girlfriend is returning from mat leave after 2-3 weeks of trying to figure out her return to work plan. Her company said they no longer have a role for her. Should we be speaking to a lawyer? I thought mat leave was protected with returning to work, and everything I've read said that they have to provide a comparable job with the same pay. She was making $70K a year, but they offered her a $2K payout for her last 2 weeks. So again, assuming that you are in BC, Alberta, or Ontario, K-Hoops 55, then no, the employer can't do that, okay? So generally, when you go on mat leave, your employer has to hold your job for you. They might hire a mat leave replacement or something like that, but that's a temporary role to backfill the role until your wife gets back to work. And in the provinces that we operate, you can have you should speak to a lawyer, absolutely. And the easiest way of doing that is reaching out to us at employmentlawyer.ca. We'll be happy to discuss with you what your rights are, employmentlawyer.ca there. We'll get you in touch with a real live legal representative who will talk to you through your options going forward. But what you read is essentially correct. Your employer has to hold your job for you, and you have to be, or your wife has to be reinstated to the same role or a very comparable role upon her return from mat leave. What I often see happening is employers hire a temp to cover, and they decide they want to keep the temp for whatever reason. Maybe they're paying the temp a bit less or what have you, and they decide to terminate the woman coming back from mat leave. And that's precisely why we have these protections for people taking parental leave. Is because we don't want these people starting a family, and then the first thing that happens is they're out of a job, right? So it's in everyone's interest that we have happy, healthy families, and employers included, right? So that's why there's that protection. So definitely KHOOP 55, reach out to us, employmentlawyer.ca. We are always happy to help people like your wife who are in this unfortunate situation, and there is definitely ways that we can help. So reach out to us. Last question we have snuck in, but this is really the last one. We have a question from Carlos Herrera Rebello, who's asking, how long after your compensation has been reduced can you file a complaint? Same position, same responsibilities, but commissions were taken out of your compensation. So Carlos, and Carlos mentions he's in Alberta. So Carlos, I want to mention that you don't have a ton of time, okay? If you sit on this and say, well, let me think about whether I'm going to accept this or not, you can sit on it for too long and you'll be deemed to have accepted the change, all right? So depending on how much income in dollars you're losing because your commission has been taken away, this might amount to a constructive dismissal. This might allow you to quit working for the employer and pursue your severance based on your income that you were earning prior to the commissions being cut, okay? Your severance can be all the way up to 2 years of salary, so it's a big amount of money. But you have to act quickly, all right? So I don't know when this happened. The absolute least amount that I've seen is 3 weeks. But definitely, if you're getting into the 3 weeks to 2 months portion, you really need to look into this and make your decision quickly, all right? So the first thing you got to do, Carlos, is reach out to us. Go to this website. We're about to wrap up the show, so go to this website, employmentlawyer.ca, and put in your information so we can contact you and discuss your case with you, all right? I would hate for you to decide, 6 months from now, this is not working for me. Had I known that I had to contact a lawyer right away, I would have done it, but I sat on it, and now I have no recourse. Okay, so reach out to us quickly. Speaking to us doesn't mean that you have to make a move with your employer. Just get some understanding of what your rights are. Okay, and then once you have the full picture, then you can make your own decision. All right, that's it for me. Thank you, everyone, for your great questions. Very interesting questions today. Definitely kept me on my toes. We have more shows coming up this week. We have another show on Wednesday with Mr. Lluc Cerda, starting at 1 p.m. Eastern. He will be talking about your employment rights in BC, Alberta, and Ontario as well. So if I haven't been able to get around to your question today, feel free to reach out on Wednesday, 1 p.m. Eastern Time. Lluc Samfiru will be taking your questions. So once again, I'm Lluc Cerda. I am the managing partner for the Calgary office of Samfiru Tumarkin, the Western Canada Employment Practice Lead. I'm very happy to have shared this half hour with you, and I hope I wish you a great rest of the day. Thank you. Bye now.